Justice Thomas?
If this were a criminal proceeding, then you would have a determination of what you're talking about. Someone would be convicted of a crime, a felony, assault or something. But here you have something that's anticipatory or predictive, where a civil court is making the determination. Just from an analytical standpoint, would there be a difference between a criminal determination and a civil determination?
So I don't think that it would make a difference with respect to whether the legislature can create categories of people who are considered dangerous or not responsible, and that's very much informed by history and tradition here. It is not the case that the only disarmament provisions that have existed over time targeting those who are dangerous are provisions that focused on those with criminal convictions. That is, of course, an important component of the law-abiding standard in particular, but we have a number of examples from throughout history of those who were disarmed even after civil adjudications or a civil-like process, and that includes—
Could you give me an example?
Sure. So, for example, mental illness. This was the category that Heller held up as the quintessential example of those who aren't responsible, even though mental illness in our legal system has always been adjudicated through civil proceedings. That was true, for example, of loyalists. The disarmament provisions on loyalists were enforced through those who were refusing to take a loyalty oath, and so there wasn't any necessity of a criminal conviction. So, too, with those who were intoxicated. You didn't need to show that they had actually been criminally convicted in order to disarm them. So I think that there is a long-standing tradition here of recognizing that individuals can be determined through this predictive judgment to be dangerous even in the absence of a criminal conviction.
Just one last question. This is a judicial determination here. Would you be able to make the same arguments if it had been an administrative determination?
I think it would be far more difficult to defend an executive branch or administrative determination because of a separate Second Amendment principle that guards against granting executive officials too much discretion to decide who and who cannot have firearms. There was some history about that in England, of course, but in the American legal tradition, these principles have been deployed through legislative judgments or through express judicial findings of dangerousness. So I don't think that we could point to the same history and tradition of giving executive branch officials that discretion.